Good evening, Attorney Aquino and classmates. We are the Group 7. We will be discussing tonight the cases under Article 3 of the 1987 Constitution, focusing on the rights of the accused, eminent domain, and police power. The reporters would be Jacqueline Ann Cruz, Joanna Marie Jose, Janian Eshvel Labodahan, and Corazon Nuke. My name is Jacqueline Ann Cruz. I'll be discussing the first topic, rights of the accused. The first case would be People of the Philippines versus Randolph Ting and Salvacion Garcia. The facts of the case are as follows. An information was filed against Tuguegarao former City Mayor Randolph Ting and City Treasurer Salvacion Garcia for violation of Section 261 of the Omnibus Election Code for issuing a treasury warrant during the 45-day election ban period as payment for 2 parcels of land to be used as a public cemetery for the city amounting to 8,486,027 pesos. During the arraignment, respondent entered a plea of not guilty to the offense charged. The said complaint was eventually dismissed by COMELEC's finding that the issuance of the treasury warrant was not for public works. However, the court set aside the COMELEC's resolution and ordered the filing of an appropriate criminal information against respondents. There was still probable cause to believe that Section 261 of the Omnibus Election Code was violated since the provisions do not require that the undertaking be for public works. After the pretrial, the prosecution filed its formal offer of evidence. On the other hand, instead of presenting their evidence, respondent filed a motion for leave to file a demurrer to evidence and subsequently a demurrer to evidence, wherein the regional trial court granted the same and acquitted the respondent. The Court of Appeals denied the petition for certiorari under Rule 65 of Rules of Court filed by the Office of the Solicitor General and affirmed the regional trials court's order. The issue of the case would be as follows: whether the regional trial court committed a grave abuse of discretion in granting the demurrer to evidence of the respondent, and second, whether the rule of double jeopardy sets when the grant to demurrer of evidence was attended with grave abuse of discretion. The court ruled that while an acquittal by virtue of a demurrer to evidence may be subject to review via petition for certiorari under Rule 65 of Rules of Court, not by a petition for review under Rule 45 like in this case, there is no showing that the RTC committed a grave abuse of discretion amounting to lack or excessive jurisdiction or denial of due process. Grave abuse of discretion has been defined as that capricious or whimsical exercise of judgment which is tantamount to lack of jurisdiction. The abuse of discretion must be patent and gross as to amount to an evasion of positive duty or a virtual refusal to perform a duty enjoined by law, or to act at all in the contemplation of law as the power is exercised in an arbitrary and despotic manner by reason of passion and hostility. The party questioning the acquittal of the accused should be able to clearly establish that the trial court bluntly abused its discretion such that it was deprived of its authority to dispense justice. A review of the records of the instant case revealed that no abuse of discretion on the part of the trial court so grave as to result in the reversal of its judgment of acquittal. While the law provides certain exceptions to the application of the rule on double jeopardy, as when the trial court prematurely terminates the prosecution's presentation of evidence, the court finds this exception inapplicable to the case at hand. It must be noted that the regional trial court herein duly gave the prosecution ample opportunity to present its case by allowing the latter to submit the pieces of evidence necessary for conviction. It cannot therefore be gainsaid that the prosecution was deprived of due process of law. To reiterate, the acquittal to be considered tainted with abuse of discretion, there must be showing that the prosecution's right to due process was violated or that the trial conducted was a sham. For the second issue, the court resolves to deny the petition on the principle of double jeopardy. The court has held that double jeopardy attaches if the following elements are present. First, a valid complaint or information. Second, a court of competent jurisdiction. Third, the defendant had pleaded to the charge. And lastly, the defendant was acquitted or convicted, or the case against him was dismissed or otherwise terminated without his express consent. The rule on double jeopardy, however, is not without exception. It has been held in the past that the only instance when the accused can be barred from invoking his right against double jeopardy is when it can be demonstrated that the trial court acted with grave abuse of discretion amounting to lack or excess of jurisdiction, such as where the prosecution was not allowed the opportunity to make its case against the accused or where the trial was a sham. For instance, there is no double jeopardy when the trial court prematurely terminated the presentation of the prosecution's evidence and fourth dismissed the information for insufficiency of evidence, and where the case was dismissed at the time when the case was not ready for trial and adjudication. In the instant case, the court finds that the element of double jeopardy are present herein. A valid information was filed against respondents for violation of 261 of the Omnibus Election Code, resulting in the institution of criminal case before the proper court of competent jurisdiction. Subsequently, respondents pleaded not guilty to the offense charged and were acquitted, the dismissal of the case against them being based on the demurrer of evidence filed after the prosecution rested its case. Second case, Jason Ivler Aguilar versus Honorable Maria Rowena San Pedro. The facts of the case are as follows. After a vehicular collision, petitioner Jason Ivler was charged before the Metropolitan Trial Court of Pasig City with two separate offenses. First is reckless imprudence resulting in slight physical injury for the injury sustained by respondent Evangeline Ponce with criminal case number 82367. And second, reckless imprudence resulting in homicide and damage to property for the death of the husband Nestor Ponce and damage to the spouse's vehicle with criminal case number 82366. Ivler posted bail for his temporary release in both cases. Ivler also pleaded guilty to the charge in criminal case number 82367 and was meted out with the penalty of public censure. Invoking this conviction, the petitioner moved to quash the information in criminal case number 82366 for placing him in jeopardy for second punishment for the same offense of reckless imprudence. The Metropolitan Trial Court refused the quashal, finding no identity of offenses in the two cases, hence elevating the matter to the Regional Trial Court of Pasig in a petition for certiorari. The RTC dismissed the petition for certiorari, narrowly grounding its ruling on the petitioner's forfeiture of standing to maintain the petition for certiorari arising from Metropolitan Trials Court order to arrest the petitioner for his non-appearance at the arraignment in criminal case number 82366. Thus, two questions are presented for resolution. Whether petitioner forfeited his standing to seek relief in the petition for certiorari when the Metropolitan Trial Court ordered his arrest for following his non-appearance at the arraignment in criminal case number 82366, and second is whether the petitioner's constitutional right under the double jeopardy clause bars further proceeding in criminal case number 82366. The court ruled that the petitioner's non-appearance at the arraignment in criminal case number 82366 did not divest him of personality to maintain the petition in certiorari. The RTC's dismissal of petitioner's civil action for certiorari review a pre-arraignment ancillary question on the applicability of due process clause to bar proceeding in criminal case number 82366 finds no basis under procedural rules and jurisprudence. The mischief in the regional trial court's treatment of petitioner's non-appearance in his arraignment in criminal case number 82366 as proof of his loss of standing becomes more evident when one considers the rules of court treatment of a defendant who's absent himself from post-arraignment hearing. Under Section 21, Rule 114 of the Revised Rules of Criminal Procedure, the defendant's absence merely renders its bondsman potentially liable on its bonds, subject to cancellation should the bondsman fail to produce the accused within 30 days. The defendant retains his standing and should have failed to surrender will be tried in absentia and his standing, and should he fail to surrender, will be tried and could be convicted or acquitted. Indeed, the 30-day period granted to the bondsman to produce the accused underscores the fact that mere non-appearance does not ipso facto convert the accused status to that of the fugitive without standing. On the other hand, the protection afforded by the Constitution shielding petitioner from prosecution, placing him in jeopardy of second punishment for the same offense, bars further proceeding in criminal case number 82366. It was held that reckless imprudence is a single crime. Its consequences, persons, and property are material only to determine the penalty. The two charges against petitioner arising from the same facts were prosecuted under the same provision of the revised penal code as amended, namely Article 365, defining and penalizing quasi-offenses. The doctrine that reckless imprudence under Article 365 is a single quasi-offense by itself and not merely a means to commit other crimes such as that conviction or acquittal of such quasi-offense bars subsequent prosecution for the same quasi-offense, regardless of its various resulting acts, undergirded this court's unbroken chain of jurisprudence on double jeopardy as applied to Article 365. Hence, the court finds merit in the petitioner's submission that the lower courts erred in refusing to extend his favor the mantle of protection afforded by the double jeopardy clause. Hence, we hold that prosecutions under Article 365 should proceed from single charge regardless of the number or severity of the consequences. In imposing penalties, the judge will do no more than apply the penalties under Article 365 for each consequences alleged and proven. In short, there shall be no splitting of charges under Article 365, and only one information shall be filed in the same first-level court. The third case would be People of the Philippines versus Aurelio Balisacan. The facts of the case are as follows. Aurelio Balisacan was charged with homicide for the death of Leonicio Bulaot. Upon arraignment, the accused entered a plea of guilty by the assistance of a counsel. At the official counsel's petition, he was allowed to present evidence to prove mitigating circumstances. Thereupon, Balisacan testified to the effect that he stabbed the deceased in self-defense because the latter was strangling him, and further stated that after the incident, he surrendered himself voluntarily to the police authorities. Based on the testimony of Balisacan, the court rendered a decision acquitting him. The issue of the case is whether an appeal challenging the acquittal of Aurelio constitutes double jeopardy. It is settled that the existence of a plea is an essential requisite to double jeopardy. In the present case, it is true the accused has first entered a plea of guilty. Subsequently, however, he testified in the course of being allowed to prove mitigating circumstances that he acted in complete self-defense. Said testimony, therefore, as the court recognized in its decision, had the effect of vacating his plea of guilty, and the court should have required him to plead anew on the charge or at least direct that a new plea of not guilty to be entered for him. This was not done. It follows that, in effect, there having been no standing plea at the time the court rendered its judgment of acquittal, there can be no double jeopardy with respect to the appeal herein. The court decided the case upon the merits without giving the prosecution an opportunity to present its evidence or even to rebut the testimony of the defendant. In doing so, it is clearly acted without due process of law and for lack of fundamental prerequisites in its action is performed null and void. The acquittal, therefore, being a nullity of want of due process, is no acquittal at all, and thus cannot constitute a proper basis for a claim of former jeopardy. Thus, the court deemed it proper to demand this case to the court of co for further proceeding under another judgment of the same court. The next case is the People of the Philippines versus the Honorable Sandigan Bayan. The important timeline of the case are as follows. In 2008, two separate complaints were filed against former Santa Magdalena Sorsogon Mayor Alejandro Gamos, Municipal Accountant Rosalyn Gile, and Municipal Treasurer Virginia Laco for violation of Section 3E of the Anti-Graft and Corrupt Practices Act and of Article 217 of the Revised Penal Code arising from the alleged illegal cash advances made in the years 2004 to 2007. In 2010, a consolidated resolution dated October 19, 2010, the Deputy Ombudsman Investigating Officer found that it is premature to determine criminal and administrative liabilities, considering that the Commission on Audit reports upon which the complaints were based were not yet final. Thus, the dismissal of the complaints was recommended without prejudice to the outcome of the review requested by Gamos, Gile, and Laco to the COA and to the refiling of the complaint if circumstances warrant. In 2011, the consolidated resolution dated October 2010 was approved in May 2011 by the acting Deputy Ombudsman. In 2015, two information for malversation of public funds were filed against Gamos, Gile, and Laco before the Sandigan Bayan. In 2017, the Sandigan Bayan dismissed the cases, finding undue delay in the preliminary investigation before the Ombudsman to the prejudice of the respondents' right to speedy disposition of their cases. The Sandigan Bayan found that 7 years has passed since the filing of the first complaint in 2008 until the filing of the information before it. While the accused may have contributed to the delay for the filing of the motion for the extension to file for their pleadings, it took the Ombudsman 2 years to act upon the complaint. The issue of the case is whether there was undue delay in the conduct of the preliminary investigation, violating respondents' right to a speedy disposition of the case, and whether the respondent's right against double jeopardy was violated. The ruling of the court says that the subsequent events revealed that the Sandigan Bayan did not err in finding undue delay in the Ombudsman's conduct of preliminary investigation. Indeed, while there may be no gaps in the sequence of events and developments in the preliminary investigation that may be considered as delay in the conduct thereof, a holistic view of the entire preliminary investigation would disclose certain shortcomings on the part of the Ombudsman, resulting undue delays in the proceedings, which, as correctly found by the Sandigan Bayan, were not satisfactorily explained by the prosecution. The filing of a motion for reconsideration should have stalled the OMB's duty to promptly file the information in court upon its finding probable cause. Section 7A provides that a leave of court is necessary before the motion for consideration is given due course where an information has already been filed in court, implying that an information may be filed in a court immediately after an approved order of resolution. Thus, we find no justifiable reason for the Ombudsman to delay the filing of the information before the Sandigan Bayan after it has already determined the existence of probable cause. Indeed, this unexplained and unreasonable institutional delays cannot impinge on the citizen's fundamental rights, no less than our constitutional guarantees all persons the right to speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. Moreover, having established that the Sandigan Bayan correctly ruled for the dismissal of the criminal cases against respondents due to the undue delay in the conduct of preliminary investigation, we find that the concept of double jeopardy becomes relevant. Double jeopardy attaches only when the following elements occur. First, the accused is charged under the complaint or information sufficient in the form and substance to sustain their conviction. Second, the court has jurisdiction. Third, the accused has arraigned and pleaded. And lastly, he or she is convicted or acquitted or the case is dismissed without his or her consent. The first and second element are undisputed. As to the third element, again, in our assailed decision, the court was misled by the petitioner's assertion in its petition that the respondent were not yet arraigned due to their refusal to appear therein. It appears, however, in this motion that the respondent have already been arraigned, satisfying thus the third element. What is crucial, however, is the fourth element, since the criminal case were clearly dismissed at the instance of the respondents, and the general rule is that the dismissal of criminal case results in acquittal made with the express consent of the accused or upon his own motion will not place the accused in double jeopardy. Thus, this rule, however, admits two exceptions, namely insufficiency of evidence and denial of the right to speedy trial or disposition of case. Indeed, respondents were the ones who filed the motion to dismiss the criminal cases before the Sandigan Bayan. The dismissal thereof was due to the violation of their right to speedy disposition, which would thus put them in double jeopardy should the charge against them be revived. The last case would be Debian Isaga Fortes versus the Senate of the Philippines et al. The facts of the case are as follows. Debian Isaga Fortes is among the 46 of the accused in criminal case number 2008-895 pending before the Regional Trial Court of San Pablo City. She and her co-accused has been charged with the violation of anti-hazing law or Republic Act number 8049 for the death of Chester Paulo Abracia due to the injuries he allegedly sustained during the initiation rites of the Tau Gamma Phi fraternity. Fortes is a member of the fraternity sister sorority Tau Gamma Sigma and was allegedly present at the premises during the initiation rites. Fortes filed a petition for certiorari before the court. At the time, she has not yet been arraigned and was at large. Fortes claims that Section 3 and 4 of the anti-hazing law are unconstitutional, as they would allow for the conviction of persons for crimes committed by others in violation of the Res Inter Alia Acta rule. She also argues that the provision violates Article 3, Section 1 and 19 of the Constitution for constituting a cruel and unusual punishment, as she was charged as principal and penalized with reclusion perpetua for a non-bailable offense. The issue of the case is whether Section 5 and 14 of the anti-hazing law should be declared unconstitutional. The court has upheld the constitutionality of the disputable presumption in criminal law. The constitutional presumption of innocence is not violated when there is a logical connection between the facts proved and the ultimate facts presumed. When such prima facie evidence is unexplained or not contradicted by the accused, the conviction founded on such evidence will be valid. However, the prosecution must still prove the guilt of the accused beyond reasonable doubt. The existence of a disputable presumption does not preclude the presentation of the contrary evidence. In fact, the constitutionality of Section 14, Paragraph 4 of anti-hazing law has already been discussed and upheld by the court in Dungo versus People. This court acknowledges that the secrecy and concealment in the initiation rites and the culture of silence within many organizations would make the prosecution of the perpetrators under the anti-hazing law difficult. Thus, this court held that the provision that the presence during the hazing is the prima facie evidence of the participation in it relates to the conspiracy of the crime. Here, the petitioner fails to show the logical relation between the facts proved, the presence of a person during the hazing, and the ultimate fact presumed that their participation in hazing as a principal is lacking. Neither has it been shown that Section 14 of the anti-hazing law does not away with the requirements that the prosecution must prove the participation of the accused in the hazing beyond reasonable doubt. An effective and appropriate analysis of the constitutional provision requires a holistic approach. It starts with the text itself, which, whenever possible, must be given their ordinary meaning, consistent with the basic principle of verba legis. The constitutional provision must be understood as being parts of the greater whole. In line with this court has found that the penalty of life imprisonment or reclusion perpetua does not violate the prohibition. Even the death penalty in itself was not considered cruel, degrading, or inhumane. Legislative acts are presumed constitutional. To be declared unconstitutional, a statute or any of its provision must shown to have clearly and unmistakably breached the Constitution. Petitioner has failed to discharge her burden of overcoming the presumption of constitutionality of Section 14 of the anti-hazing law. Thank you. That will be all for me, and the next topic would be discussed by my groupmates.
Thank you, Ms. Cruz, for that very informative discussion on the rights of the accused. Let us now go to Section 9 of Article 3, which states that private property shall not be taken for public use without just compensation. So what is eminent domain? Eminent domain in the Philippines is an inherent power that empowers the government to acquire private properties for public use, subject to the payment of just compensation to the property owner. It is an important tool for the government to carry out infrastructure projects, land reform initiatives, and other development activities that serve the greater public interest. So here are some key points to consider when discussing eminent domain in the Philippines. As a constitutional basis, eminent domain in the Philippines is primarily governed by Article 3, Section 9 of the 1987 Constitution. It states that private property shall not be taken for public use without just compensation. The government's exercise of eminent domain must always serve a legitimate public purpose, such as building roads, bridges, schools, hospital, or implementing agrarian reform programs. The Constitution mandates that the property owner must receive just compensation, which should be determined through a fair and transparent process. Just compensation should be equivalent to the property's fair market value at the time of the taking. The property owners have the right to due process when their properties are subject to expropriation. So this includes proper notice, an opportunity to be heard, and the right to challenge the government's valuation of their property. So eminent domain also plays a crucial role in the implementation of the Comprehensive Agrarian Reform Program. This seeks to redistribute agricultural lands to landless farmers. So the government acquires private agricultural lands and redistributes them to a qualified beneficiaries under CARP. As for the legal remedies, the property owners have the right to challenge the government's exercise of eminent domain in court if they believe that their rights are being violated. The court's role is to ensure that the government adheres to the law and respect the property owner's rights. So as to the social and economic impact, eminent domain, when used judiciously, can have a significant impact on the country's development, enabling crucial infrastructure projects and land reform efforts. In summary, eminent domain in the Philippines is a legal mechanism that allows the government to acquire private property for public purposes while respecting property owners' rights through just compensation and due process. This remains a critical tool for the nation's development while requiring a careful balance between the public interest and individual property. So let us now go to cases relating to eminent domain. First, we have the case of Republic versus Jose Gamia Consuelo Diaz Heirs Association. So in this case, the respondent, Jose Gamir Consuelo Diaz Heirs Association, was the registered owner of a parcel of land the land in this case forms part of the Santa Ana Avenue, a national road. In 2005, a series of negotiation took place between them and the Republic of the Philippines through the DPWH. They agreed that the respondent would sell the property for 275,000 and thereafter executed a deed of absolute sale. And then the property was registered under the Republic's name. The respondent then filed a complaint before the RTC where it alleged that the parcel of land was taken by the DPWH in 1957 and the value of just compensation in the deed of sale was 275, and they also claimed that they made several verbal and written demands to petition for the payment of interest in 1957 but to no avail. They also claimed that it had a right to receive interest because DPWH had not paid just compensation when it occupied the property in 1957. The RTC dismissed the complaint for lack of merit, while on appeal, the appellate court reversed the decision of the RTC. It ruled that the deed of sale in question does not fulfill the constitutional requirement of just compensation because it not only specifies the correct amount to be paid, but also the need for prompt payment within a reasonable time following the property seizure. It further held that without timely payment, compensation cannot be considered just because it fails to address the immediate deprivation suffered by the property owner in terms of both the land and its associated income. Legal interest should accrue from the moment that the property is taken until the actual payment is made to restore the landowner's position to what it was before the taking occurred. Importantly, the deed of sale does not constitute a waiver of interest payment because the determination of just compensation in eminent domain cases is a judicial function, and the taking of the property is an exercise of the state's inherent power of eminent domain. The petitioner argued before the Supreme Court that since the deed of absolute sale was executed, it is not entitled to interest without violating the parole evidence rule. So the deed of absolute sale was voluntarily executed and contained the stipulation relating to the conveyance of the property. It argued that the lack of stipulation regarding the payment of interest in the contract amounted to an abandonment since the respondent raised the same during the negotiation. They asserted that the payment of interest before the execution of the deed of absolute sale. The issue in this case is whether the respondent is entitled to receive payment of interest notwithstanding the absence of any stipulation in the deed of absolute sale with the petitioner. The court ruled in the negative. The Supreme Court defined the meaning of eminent domain, which states that it is the inherent power of a nation or a sovereign state to take or sanction the taking of private property for a public use without the owner's consent, conditioned upon payment of just compensation. Even if it is an inherent power, it is not absolute because it has limitation imposed by the Constitution, such as Section 1 of Article 3, which provides that no person shall be deprived of property without due process of law, as well as Section 9. Therefore, for the state to exercise its power of eminent domain, the following requirements must be present. First, that it must be for a particular purpose, and second, that just compensation is paid to the property owner. The court also defined just compensation. In summary, just compensation pertains to the timely or prompt payment of an adequate value sufficient to recoup the loss suffered by the property owner. Also, in this case, the court differentiates expropriation and voluntary sale. Expropriation is an involuntary sale where the landowner is practically an unwilling seller. So provided that all the requisites for its exercise are present, a private individual cannot resist the state's exercise of its inherent power of eminent domain. There is nothing that precludes the government from entering into a negotiated sale with a private landowner to acquire property to be devoted for a public purpose. In fact, the expropriation proceeding or court intervention would be unnecessary if a deed of sale is executed where the parties come to an agreement as to the price of the property to be sold. So, for voluntary sale, it is when the parties could freely negotiate the terms and conditions of the contract. They can include a stipulation concerning the payment of interest. In voluntary sale, the state does not exercise its power of eminent domain. So when does the court award legal interest? First is that when there is an absence of concurrence between the landowner and the government, and when the state had commenced expropriation proceeding. In the case, the petitioner and respondent voluntarily and freely executed and entered into a deed of sale covering the latter's property. The document represents the will of the party. So the award of legal interest in cases where the government acquires private property through voluntary sale is not a matter of law. So unlike in cases where the state exercises its power of eminent domain or when a party initiates expropriation proceedings in negotiated sale, there is an existing contract that governs the relation of the parties and determines the respective rights and obligations. So in turn, this contractual stipulation should be complied with in good faith unless they are contrary to law, morals, good customs, public order, or public policies. So in the case, the respondents admit that upon negotiation, it agreed to sell its property to petitioner for the amount stated in the deed of absolute sale. However, prior to the execution of the deed, it had demanded for the payment of interest to be computed from 1957, but the petitioner rejected it. The respondent did not also make any reservation for it to claim interest. So this ruling of the Supreme Court was supported by the parole evidence rule under the rules of court, but this rule is subject to certain exception, one of which is when the existence of other terms agreed to by the parties or successors in interest after the execution of the written agreement. So in the case, the deed of absolute sale between the parties does not contain any provision regarding the payment of interest. The petitioner agreed to convey its property upon full payment for the purchase price without reservation of interest. So no parole evidence can be admitted to support the respondent's claim of interest because it never put in issue in its complaint the ambiguity or the validity of the deed of absolute sale or its failure to reflect the party's true intention. The Court of Appeals also the Supreme Court disagrees with the Court of Appeals assertion that the respondent had no choice but to sign the deed of absolute sale without an interest payment provision. There were no claims of coercion or any impairment of consent in the signing of the document, and the respondent was not forced into this agreement while at a disadvantage. So if the respondent strongly desired legal interest, they had the option to initiate expropriation proceeding or at least include a clause in the finalized deed of sale reserving the right to claim legal interest. Importantly, the respondent did not raise any objection or protest when they acknowledged receiving the full purchase price specified in the deed of absolute sale. Okay, so let us now go to the case of Land Bank of the Philippines versus Franco. So this case involves a petition for review on certiorari challenging the decision made in a dispute over the valuation and compensation for the agricultural land subject to the Comprehensive Agrarian Reform Program. So in this case, Lucy Grace Franco and Elma Gloria Franco, or the Francos, owned a parcel of land, an agricultural land in Iloilo covered by a transfer certificate of title. They offered their lands to the Department of Agrarian Reform under CARP in 1995, with a portion being acquired for distribution to agrarian reform beneficiaries. So during the summary proceedings before the DAR, the land was initially valued at 714,000, a valuation that the Francos disagreed with. The DARAP later increased the valuation to 739,000, which the Francos withdrew from the Land Bank of the Philippines. So unsatisfied again with the valuation, the Francos filed a complaint in August 2000 before the RTC acting as the Special Agrarian Court to determine just compensation. They later amended the complaint to include Land Bank and the Secretary of Agrarian Reform and the additional tenant beneficiaries who were not part of the original filing. So the the Special Agrarian Court decision determined that the just compensation is 1.24 million for the land area actually taken by the government. The court ordered the land bank to pay the remaining balance of 288,000 with legal interest at 12% per annum from April 25, 1996 until full payment. Additionally, the court held that the Francos were entitled to a 5% cash payment as an incentive for voluntary offering their land for sale. The court arrived at this decision after considering various factors, including the Francos' initial asking price, tax declaration, assessment, and the social and economic contribution. The Court of Appeals affirmed the Special Agrarian Court's decision, but it removed the 12% legal interest on the outstanding amount. The Land Bank then filed a petition for review on certiorari before the Supreme Court. Land Bank contends that the Special Agrarian Court wrongfully applied the modified valuation formula and misunderstood the 5% cash incentive. So they argued that the Special Agrarian Court deviated from the valuation formula and the administrative guidelines established by the Department of Agrarian Reform. The Francos, on the other hand, argued that the Special Agrarian Court had an exclusive jurisdiction to determine just compensation and that the 5% cash incentive was an additional award for the landowners who voluntarily sold their land for eminent domain purposes. So the issue in this case is whether or not the Court of Appeals erred in affirming the Special Agrarian Court's valuation of just compensation using a variation of the basic general formula provided for by the Department of Agrarian Reform Administrative Order Number 5. The court ruled that yes, that in 1988, the Congress passed the Comprehensive Agrarian Reform Law to emphasize its commitment to agrarian reform. So in response to these changes, the Judiciary Reorganization Act or the Batas Pambansa Bilang 129 granted the Regional Trial Court the exclusive authority to handle civil and special cases that were previously managed by Agrarian Relations Court. Moreover, through Section 56 and 57 of the Comprehensive Agrarian Reform Law, special agrarian courts were given special jurisdiction to handle special agrarian-related cases. These regional trial courts, when acting as special agrarian courts, they possess exclusive jurisdiction over determining fair compensation for landowners and prosecuting criminal offenses under the Comprehensive Agrarian Law. On the other hand, the Department of Agrarian Reform Adjudication Board or the DARAB primarily plays a role in the initial administrative determination of just compensation. So the Supreme Court again defined just compensation as the full and fair equivalent of the property taken from its owner by the expropriator. The measure of the taking is not the taker's gain, but the owner's loss. The term just intensifies the term compensation to obtain a real, substantial, full, and ample equivalent for the property taken. The jurisdiction of the trial court sitting as the Special Agrarian Court is not any less original and exclusive because the Department of Agrarian Reform passes upon the question of just compensation first. Also, under CARP, it identifies the factors to be considered for the determination of just compensation. So in determining just compensation, the following shall be considered: the cost of the acquisition of the land, the current value of like properties, its nature and actual use and income, the sworn valuation by the property owner, the tax declarations, and the assessment made by the government assessors shall be considered. The social and economic benefits contributed by the farmers and the farm workers and by the government to the property, as well as the non-payment of taxes or loans secured from any government financing institution, shall also be considered as additional factors to determine its valuation. So under Administrative Order number 565, it provides a formula for determining the value of the lands covered by the voluntary offer to sell or VOS or compulsory acquisition or CA programs. So the formula considers capitalized net income, the comparable sales, and the market value per tax declaration factors. So this is the basic formula provided by the administrative order. So the basic formula is LV is equals to CNI multiplied by 0.6 plus CS times 0.3 plus MV multiplied by 0.1. So LV is the land value, the CNI is the capitalized net income, the CS is the comparable sales, and the MV is the market value per tax declaration. So this formula helps in determining just compensation, but courts have the discretion to deviate from them if the circumstances warrant it. The court held that this formula are considered, but they are not final determination of the just compensation because the determination of just compensation rests with the Special Agrarian Court, which may consider other factors affecting the property's value. So in the case, the Supreme Court held that the SAC found that a slight deviation was in order. It held that there were other factors present that must also be taken into account, deeming the petitioner's valuation to be unrealistically low. The SAC proceeded to compute just compensation according to the factors in the administrative order and the market value of the property as shown in the tax declaration. The Supreme Court cited the case of Alfonso versus Land Bank, which ruled that any deviation to the basic formula made in the exercise of judicial discretion must be supported by a reasoned explanation grounded on the evidence on record. A computation made by a court made in disregard of the factors provided by law and the implementing rules amounts to a grave abuse of discretion and must be struck down. So in the case, the Special Agrarian Court's computation of just compensation resulted in a double take-up of the market value per tax declaration of the property. This method of valuation has already been considered in Palmares as a departure from the mandate of law and basic administrative guideline. Therefore, the just compensation for Lucy Grace Franco and Elma Gloria Franco is 739,000 as calculated by the Land Bank of the Philippines and the Department of Agrarian Reform. It will accrue 12% legal interest from the time of taking until June 30, 2013 and the 6% legal interest from July 1, 2013 until fully paid. Okay, for the last case, let us now go to National Transmissions Corporation versus Spouses Taglao. So the facts of the case are as follows. The National Transmission Corporation is a transferee in interest of the NPC, a government entity created to undertake the development of hydroelectric generation of power and production of electricity from any and all sources. Transco filed before the RTC a complaint for eminent domain against the spouses Mariano and spouses Taglao to enable it to construct and maintain its project. So the spouses Taglao are the owners of a parcel of land, and the NPC sought to acquire an easement of right of way. The spouses Taglao sought to dismiss the eminent domain case, while the NPC filed an urgent ex parte motion for the issuance of writ of possession. The RTC denied the motion to dismiss and granted the NPC's writ of possession. It also directed the parties to submit the names of their recommended commissioners for the purpose of determining just compensation. The NPC recommended Commissioner Engineer Abshedo where he submitted the commissioner's report recommending 156,000 as just compensation for the subject portion. As for the recommended petitioner, Attorney Zabalero, he submitted a report recommending 12 million as just compensation. The RTC then fixed the market value of the property at 1,000 square meter with a total of 509,000 for just compensation. Thus, the Court of Appeals denied the NPC's appeal and affirmed the RTC's ruling. The Transco argued that just compensation must be determined as of the date of the taking of the property or the filing of the complaint, whichever comes first. So in the case, it filed the complaint for eminent domain on November 24, 1985 and took possession of the property on October 9, 1996. So the filing of the complaint taking place first, the NPC asserts that the compensation must be determined as of the time of its filing, not when it was taken in 1996. It also claimed that the RTC and the CA's calculation of just compensation was not based on any established rule, principle, or evidence. According to Transco, the RTC and CA merely speculated and made a rough calculation of the just compensation. So the issue in this case is whether or not the valuation is correct. The Supreme Court ruled in the negative. Just compensation is defined as the full and fair equivalent of the property taken from its owner by the expropriator. Just compensation is that sum of money which a person desirous but not compelled to buy, and an owner willing but not compelled to sell would agree on a price to be given and received. Therefore, it is the measure. The measure is not the taker's gain but the owner's loss. While the market value may be one of the bases of the determination of just compensation, the same cannot be arbitrarily arrived at without considering the factors to be appreciated in arriving at the fair market value of the property. For example, the cost of acquisition, the current value of like properties, its size, shape, location, as well as the tax declaration. The court held that we should also to remember that just compensation should be computed based on the fair value of the property at the time of the taking of its taking or filing of the complaint, whichever came first. So in the case, the action for eminent domain was filed by NPC on November 24, 1995. It took possession of the property on October 9, 1996. So since the filing of the complaint for eminent domain came ahead of the taking, just compensation should be based on the fair market value of the spouses at the time of the filing of the NPC's complaint on November 24, 1995. So as for the valuation of the property, the Supreme Court rejected the valuations made by the commissioner on the ground that they were not based on the market value of the property at the time of the filing of the NPC's complaint for eminent domain. The market value of the property could have been different in 1993 and 2000. The commissioners only based their computation on the property's tax declaration without taking into consideration other factors such as acquisition value of like properties in 1995, size, shape, and location. Hence, the court fixed the market value at 1,000 per square meter, and it also ruled that the RTC's decision lacked a clear basis for its valuation of the property at 1,000 pesos per square meter. It was not supported by any documentary evidence, and the CA upheld this valuation, and that it also ruled that the Court of Appeals upheld this valuation based on a speculative inference that it might have been the fair market value in 1995, but this reasoning lacked concrete evidence. So the court held that both RTC and the Court of Appeals conclusion were speculative and lacked reliable basis, contravening the requirements for just compensation to be determined based on the established rules, legal principles, and competent evidence. Furthermore, the RTC's computation of just compensation was improperly made as it correctly applied a 10% payment based on a specific law when the NPC was seeking easement of right-of-way rather than the property acquisition. Therefore, the court should disregard those flawed valuation and computation. As for the computation of just compensation, the court held that the RTC and the Court of Appeals formula for just compensation are incorrect. So this was the formula used by the lower court, but this was not not accepted by the Supreme Court. The Supreme Court held that just compensation should not only be the 10% of the market value of the subject property. Instead, this formula was adopted by the court. The subject property's market value should be fixed by the RTC, taking into consideration the cost of acquisition of the land involved, the current value of the like properties, its size, shape, location, as well as the tax declaration at the time of the filing of the NPC's complaint. The unpaid balance of just compensation for spouses Taglao will accrue legal interest at a rate of 12% per annum from the date of the complaint, which was filed on November 24, 1995. However, this 12% interest is applicable only until June 30, 2013, starting from July 1, 2013, and until the full compensation is paid, the interest rate will be reduced to 6% per annum. So this application of 6% interest rate aligns with the prevailing legal precedents regarding the monetary compensation in expropriation cases. The court set aside the decision and the rest. So in the end, the court set aside the decision and the resolution of the Court of Appeals, and the court has no alternative but to remand the case to the court of origin for proper determination of just compensation. So, and that's it for my discussion on Section 9 of Article 3. I will now give the spotlight to Ms. Labodahon to continue the discussion on eminent domain.
Good evening, my name is Janine Ishmael Labodahon, and I will continue the reporting of cases under eminent domain. The next case is Republic of the Philippines versus Sena et al. The facts of the case are as follows. As part of its C5 road extension widening project, petitioners sought to acquire respondents' properties, all of which are located along Old Balara, Quezon City.
property. When attempts by petitioner to obtain the subject properties through negotiated sale failed, petitioner instituted 5 separate complaints for expropriation against respondents between November 2010 and February 2011, which were later consolidated before the RTC. On June 1, 2011, petitioner filed an ex parte motion for the issuance of writ of possession with the RTC, stating that it had deposited with the Land Bank of the Philippines an amount equivalent to 100% of the current zonal valuation of the subject properties in compliance with Section 4A of RA 8974. On June 17, 2011, the RTC issued a writ of possession ordering the sheriff to place the petitioner in possession of the property. Subsequently, on December 12, 2011, the RTC issued an order of condemnation and created a board of commissioners. The RTC then, in a resolution dated July 5, 2011, fixed the just compensation at 25,000 per square meter, ruling that this court, in determining the just compensation for the property subject matter of this appropriation case, cannot take into consideration the BIR zonal valuation, as the same is always relatively less than the fair market value. The RTC denied petitioner's motion to dismiss, and the Court of Appeals affirmed. So the issue in this case is whether or not the Court of Appeals was wrong in affirming the RTC's determination of just compensation for respondents' expropriated property at 25,000 per square meter. The court ruled in the negative. In this case, in claiming that evidentiary weight should be accorded by the RTC to the recommendation of the Bureau of Customs, petitioner is asking the court to recalibrate and weigh anew the evidence already passed upon by the lower courts, yet petitioner has not alleged, much less proven the presence of any of the exceptional circumstances that could warrant a deviation from the rule that this court is not a trier of facts. On this ground alone, the denial of the petition is warranted. That the RTC found the amounts recommended by the Board of Commissioners or the Philippine Appraisal Company Incorporated to be incomplete indication of the fair market value of the property cannot be considered an indicum of arbitrariness. On the issue regarding the interest due on the amount of just compensation, petitioner owes respondents the unpaid portion of the fair market value, that is the balance between the fair market value as finally determined by the court, computed at 25,000 per square meter, and the amount of initial deposit made by the government. Interest on the unpaid portion, which interest begins to run from the date of the taking, and interest on the fair market value from the date of the taking to the date of the initial deposit by petitioner. Inasmuch as the filing of the complaints for expropriation between November 2010 and February 2011 preceded the actual possession of the property on June 17, 2011, just compensation and the corresponding interest shall be determined based on the respective dates of the filing of the complaints for expropriation. Further, RA 8974 requires the government to pay at 2 stages. First, immediately upon filing the complaint, the initial deposit, which is 100% of the value of the property based on the current relevant zonal valuation of the BIR, and the value of the improvements or structures sought to be expropriated. And second, the just compensation as determined by the court when the decision becomes final and executory, in which the case the implementing agency shall pay the owner the difference between the just compensation as determined by the court and the amount already or initially paid. Absent full payment of just compensation, interest on the unpaid portion, which is the just compensation determined by the court at the time the decision becomes final and executory, minus the initial deposit, likewise runs as a matter of law and follows as a matter of course in order to place the owner in a position as good as the position he was before the taking occurred. The underlying reason is simple. Compensation would not be just if the government does not pay the property owner interest on the just compensation from the date of the taking of the property. While it is ideal that just compensation be immediately made available to the property owner so that he may derive income from that compensation, that is not always the case. If full payment is not paid for the property taken, the state must pay for the shortfall in the earning potential that the owner immediately lost due to the taking. Consequently, interest on the unpaid portion becomes due as compliance with the constitutional mandate on eminent domain and as a basic measure of fairness. In a situation where the property is taken for public use before the initial deposit is made, such as in this case, Interest must necessarily accrue from the time the property is taken to the time when the compensation is actually paid or deposited with the court, in order to ensure that the owner is fully placed in a position as full as he was before the taking occurred. Next case is Alfonso versus Land Bank of the Philippines. The facts of the case are as follows. Cynthia Palomar was the registered owner of two parcels of land. One is located in San Juan, Sorsogon City, and the other in Bibimpinahan, Sorsogon City. After the effectivity of RA 6657, the Department of Agrarian Reform sought to acquire the subject lands. The owner prior to petitioner rejected the valuation of the DAR, resulting to land valuation cases subsequently being filed before the DAR Provincial Adjudication Board. Subsequently, the Land Bank filed a motion seeking reconsideration of the DARPAB's valuations. Both petitioner and respondent filed separate actions for the judicial determination of just compensation of the subject properties. The RTC, sitting as Special Agrarian Court, found the valuations of both the LBP and the provincial adjudicator to be unrealistically low. LBP argued before the Court of Appeals that there is nothing in Section 17 of RA 6657 which provides that capitalized income of a property can be used as a basis in determining just compensation. Thus, when the RTC used the capitalized income of the properties as a basis of valuation, it actually modified the valuation factor set forth RA 6657. The CA reversed the findings of the RTC. The main issue in this case concerns the legal duty of the courts in determination of just compensation under RA 6657 in relation to Section 17 of RA 6657 and the implementing formulas of the DAR. The issue in this case is whether or not the courts are obliged to apply the DAR formula, which was discussed earlier by Ms. Jose in cases where they are asked to determine just compensation for property covered by RA 6657. The court ruled in the affirmative. The determination of the just compensation is a judicial function. The justness of the enumeration of the valuation factors in Section 17, the justness of using a basic formula, and the justness of the components and their weights that flow into the basic formula are all matters for the courts to decide. Until Section 17 or the basic formulas are declared invalid in a proper case, they enjoy the presumption of constitutionality. RA 9700 expressly provides for the mandatory consideration of the DAR basic formula. In other words, in the exercise of the court's essentially judicial function of determining just compensation, the RTC, Special Agrarian Courts, are not granted unlimited discretion and must consider and apply RA number 6657. The factors listed under Section 17 of RA 6657 and its resulting formulas provide a framework of structure for the computation of just compensation, which ensures that the amounts to be paid to affected landowners are not arbitrary, absurd, or even contradictory to the objects of agrarian reform. Until and unless declared invalid in a proper case, the DAR formulas partake of the nature of statutes which under the 2009 amendment became the law itself, and thus have in their favor a presumption of legality, such that courts shall consider and not disregard these formulas in determination of just compensation for properties covered by the Comprehensive Agrarian Reform Program. When faced with situations which do not warrant the formula's strict application, courts may, in exercise of their judicial discretion, relax the formula's application to fit the factual situations before them, subject only to the condition that they clearly explain in their decision their reasons for the deviation undertaken. It is thus entirely allowable for a court to allow a landowner's claim for an amount higher than what would otherwise have been offered for as long as there is evidence on record sufficient to support the award. So the next case is Rebadulia versus Republic of the Philippines. The facts of the case are as follows. Paz E. Rebadulia is the widow of Pablo G. Rebadulia, with whom she had 7 children. On March 17, 1997, the Department of Public Works and Highways took parcels of land belonging to the Rebadulias for its small water impounding management project in Macagtas, Catarman, Northern Samar. The Rebadulias rejected the price offered by the DPWH at 2 pesos and 50 centavos per square meter, based on the valuation of the Provincial Appraisal Committee. No expropriation proceedings were instituted by the DPWH. And then in 1998, the Rebadullas wrote to the Swim Project Management Office requesting for a reappraisal for their property and stating that 200 per square meter was its fair value but was denied. The swim project manager requested a reappraisal from the PAC, which was later also denied. And thereafter, the Rabadullas wrote to the Department of Finance Bureau of Local Government Finance asking for the reappraisal of their properties. In 2002, the Rabadullas, through counsel, wrote to Engineer Buen with the final demand of 33 million or 200 per square meters of their properties. Subsequently, they filed a complaint for mandamus and damages before the RTC against the Republic and Secretary of Public Works and Highways and Engineer Buen, praying that the Republic or DPWH pay just compensation in the amount to be determined as the fair market value by the RTC for the taking and use of the properties. The government maintains that the determination of just compensation is improper in the mandamus proceedings because the same is available only to compel performance of a ministerial duty and not one involving the exercise of sound judgment and discretion that takes into consideration several factors such as land classification and location. The issue in this case is whether or not mandamus is proper for recovery of just compensation, and the court ruled in the negative. Jurisprudence clearly provides for the landowner's remedies when his property is taken by the government for public use. He may recover his property if its return is feasible. If it is not, he may demand payment of just compensation for the land taken. In this case, the return of the subject properties is no longer feasible as they had been used in the construction of dams for the DPWH swim project, which was already completed. Thus, the Rebadullas relief was to recover just compensation. The Rebadullas complaint plainly sought to recover just compensation for the taking of their properties in an amount to be determined as the fair market value by the court. It has been more than two decades since the subject properties were taken for public use without compensation to the Rebadullas. As the Court of Appeals explained, to construe the mandamus case solely as a means to compel the government to just file expropriation proceedings would only further prolong injustice. Another issue presented is the case of how much Rebadullas should be paid of just compensation. Sustained by the Court of Appeals, the RTC fixed the just compensation based on the zonal value of 7 pesos per square meter effective from December 25, 1995 to December 27, 2002. The RTCs, however, erred in fixing the just compensation based solely on the zonal valuation of the properties. Zonal valuation is simply one of the indices of the fair market value of the real estate, and it cannot be the sole basis of just compensation. Just compensation is the sum equivalent of the market value of the property, broadly described as the price fixed in open market by the seller in the usual and ordinary course of legal action or competition, or the fair value of the property as between one who receives and who desires to sell it, fixed at the time of the actual taking by the government. Among the factors to be considered in determining the fair market value of the property are the cost of acquisition, the current value of like properties, its actual or potential uses, and in particular case of land, its size, shape, location, and the tax declaration. The measure is not the taker's gain but the owner's loss. To be just, the compensation must be fair not only to the owner but also to the taker. Since the determination of the value of the property is factual in nature, the court finds a need to remand the case to the trial court to determine its value. The next case is Republic of the Philippines versus the heirs of Bourbon et al. The facts of the case are as follows. Napocor entered a property located in Barangay San Isidro, Batangas City in order to construct and maintain transmission lines. Respondent heirs of Saturnino Bourbon owned the property. Napocor filed a complaint for expropriation in the RTC in Batangas City, seeking the acquisition of an easement of right of way over a portion of the property. The respondents maintained that Napocor had not negotiated with them before entering the property and that the entry was done without their consent. Nonetheless, they tendered no objection to Napocor's entry, provided it would pay just compensation not only for the portion sought to be expropriated, but for the entire property whose potential was greatly diminished, if not totally lost, due to the project. During the pendency of an appeal, Napocor filed a manifestation and motion to discontinue expropriation proceedings, informing that the parties failed to reach an amicable agreement that their property sought to be expropriated was no longer necessary for public purpose because of the intervening retirement of the transmission lines installed on the respondent's property, that because the public purpose for which such property would be used thereby ceased to exist, the proceedings for expropriation should no longer continue, and the state was now duty bound to return the property to its owners, and that the dismissal or discontinuance of the expropriation proceedings was in accordance with Section 4, Rule 67 of the Rules of Court. The issue in this case is whether or not the expropriation proceeding should be discontinued or dismissed pending appeal. The court ruled in the affirmative. Before anything else, we should note that the nature of the power of eminent domain. The right of the eminent domain is the ultimate right of the sovereign power to appropriate not only the public but the private property of all citizens within the territorial sovereignty to public purpose. But the exercise of such right is not limited, for two mandatory requirements should underlie the government's exercise of the power of eminent domain. That it should be for a public purpose, and that just compensation should be paid to the property owner. These requirements partake the nature of implied conditions that should be complied with to enable and condemn or to keep the property expropriated. It is essential that the element of public use of the property be maintained throughout the proceedings of its expropriation. It is not denied that the purpose of the plaintiff in this case was to acquire the land in question for public purpose. The fundamental basis, then, of all actions brought for the expropriation of lands under the power of eminent domain is public use. Therefore, the very moment that it appears at any stage of the proceedings that the expropriation is not for a public use, the actions must necessarily fail and should be dismissed for the reason that the action cannot be maintained at all except when the expropriation is for some public use. That must be true even during the pendency of an appeal or at any stage of the proceedings. If, for example, during the trial in the lower court, it should be made to appear to the satisfaction of the court that the expropriation is not for some public use, it would be the duty and the obligation of the trial court to dismiss the action. And even during the pendency of the appeal, if it should be made to appear to the satisfaction of the appellate court that the expropriation is not for public use, then it would become the duty and the obligation of the appellate court to dismiss it. The retirement of the transmission lines necessarily stripped the expropriation proceedings of the element of public use. To continue with the expropriation proceedings despite the definite cessation of the public purpose of the project would result in the rendition of the invalid judgment in favor of the expropriator due to the absence of the essential element of public use. Having said that, we must point out that Napocor entered the property without the owner's consent and without paying just compensation to the respondents. Neither did it deposit any amount as required by law prior to its entry. The Constitution is explicit in obliging the government and its entities to pay just compensation before depriving any person of his or her property for public use. Considering that in the process of installing transmission lines, Napocor destroyed some fruit trees and plants without payment, and the installation of the transmission lines went through the middle of the land as to divide the property into 3 lots, thereby effectively rendering the entire property inutile for any future use. It would be unfair for Napocor not to be made liable to the respondents for the disturbance of their property rights from the time of entry until the time of restoration of the possession of the property. In view of the discontinuance of the proceedings and the eventual return of the property to the respondents, there is no need to pay just compensation to them because their property will not be taken by Napocor. Instead of full market value of the property, Napocor should compensate the respondents for the disturbance of the property rights from the time of entry until the time of restoration of the possession by paying to them actual or other compensatory damages. This should mean that the compensation should be based on what they actually lost as a result by reason of their dispossession of the property and of its use, including the value of the fruit trees, plants, and crops destroyed by Napocor's construction of the transmission lines. Considering that the dismissal of the expropriation proceedings is a development occurring during the appeal, the court now treats the dismissal of the expropriation proceedings as producing the effect of converting the case into an action for damages. For that purpose, the court remands the case to the court of origin for further proceedings. The court of origin shall treat the case as if originally filed as an action for damages. That concludes my report, and to continue, I would like to pass the spotlight to Ms. Nito. Thank you.
Within as a just compensation representing the total amount of value of the property based on the surrender value in which the court granted, and as consequential damages, the DPWH was ordered to pay the value of the capital gains tax and other taxes necessary for the transfer of the disputed property in its name. The DPWH filed a motion for reconsideration seeking to delete the award of replacement costs, and the court granted it in part. The court resolved excluding the replacement cost, but when it comes to payment of capital gains tax and other transfer taxes as the value of the consequential damages, the court find that the DPWH is liable to pay to the spouses. So, and the issue in this case is whether or not consequential damages can be awarded equivalent to the capital gains tax and other transfer taxes. The court ruled no. In Republic v. CA, the court explained the definition of the consequential damages, in which the consequential damages can be awarded to the owner if, as a result of expropriation proceedings, the remaining portion not so expropriated suffers from an impairment or decrease in the values. So to recall, in this case, the expropriation covered the entire property of the spouses inside. So there is no basis for an award of consequential damages where there is no remaining portion to speak of, as in this case. So to remember, consequential damages only can be awarded if there is a remaining portion of the property that not so expropriated but suffers impairment or decrease in the value. Napocor versus heirs of Serra. The facts are as follows. Napocor filed a complaint of eminent domain before the RTC of Cabancalan City against the heirs of Serra, alleging to enable the Napocor to construct and maintain its transmission lines, Island Grid Project, a project for public purpose, and an urgent to acquire an easement right of way over the portions of parcels of land owned and possessed by the respondents. So the RTC dismissed the case without prejudice for failure to prosecute, but later rendered its decision ordering the expropriation of the land in dispute. So in determining just compensation, RTC considered and gave weight to the data provided by the Department of Finance based on zonal value for 1997. On appeal, Cebu City affirmed the decision of the RTC. So Napocor filed a motion for reconsideration, but it was denied. The issue in this case is that whether or not the amount of just compensation awarded to the respondent should be based on the prevailing price and character of the property at the time of the filing of the complaint for eminent domain. The court ruled yes. As correctly noted by the CA Cebu City, the RTC properly ascertained the value, the character of the property as of the time of the filing of the complaint, and pursuant to the period under the rules of court and jurisprudence. So the appellate court observed that the trial court did not consider the improvements on the subject properties as of 2006, which is certainly not the proper period for the correct determination of just compensation in this case. And though the trial court made mention of the observations of the commissioner, particularly the improvement had on the subject properties after the year 1998 or after the filing of the original expropriations complaint thereon, as a closer scrutiny of the rationalizations of the trial court reveals that it did not take into consideration these improvements in determining just compensations. So also, it is well settled that factual findings of the trial court and appellate courts will not be disturbed by the Supreme Court unless they are grounded entirely on speculations, surmises, or conjectures, among others. Napocor in this case, submissions raises a new allegation. And as a rule, the court is not a trial of facts. The Supreme Court only rules on question of law, distinctly set forth in the petition, ought to be raised before the Supreme Court. So the petition now refers to a particular period, that is the year 2006, on which allegedly the trial court erroneously based its determination. This strains the court to review the evidence. So the court find no valid ground that would warrant a reversal of the factual findings of the appellate court or any reasonable basis to treat them as an exception. So in this case, the Napocor based new allegations before the Supreme Court and not on the RTC. So it is well settled that only the questions of law and not the questions of facts can be ruled by the Supreme Court. Let us now go to the police power. Police power is the state's authority to enact legislation that may interfere with personal liberty or property in order to promote general welfare. So it has two components. It is the imposition of restraint upon liberty or property, and in order to foster common good. The characteristics are, it is the most pervasive, least limitable, and most demanding of the three inherent powers. Requisites of a valid police power are lawful subject, which means that the interests of the public generally, as distinguished from those of a particular class, requires the interference of the state. Then the lawful means, the means employed are reasonably necessary for the attainment of the object sought and not unduly oppressive upon individuals. Police power can be delegated to the lawmaking bodies of the LGUs. So the requisites are as follows. For it to be a valid exercise of police power by the delegate, it must be granted by law, and it must not be contrary to law and within the territorial limits of the LGUs. So the test to determine the validity of an ordinance for the LGU are, it must not contravene to the Constitution or any statute, must not be unfair or oppressive, must not be partial or discriminatory, must not prohibit but may regulate trade, must be general and consistent with public policy, and must not be unreasonable. So the test of a valid delegation of legislative power to administrative bodies are completeness test, which means that the law must be complete in all its terms, and the condition when it leaves the legislature such that when it reaches to the delegate, the only thing he will do is to enforce it. Then the sufficient standard test. There must be an adequate guidelines or stations in the law to map out the boundaries of the delegate's authority and prevent the delegation from running riot. So let us now go to the case of Zabal versus Duterte. The facts are as follows. This case stemmed in the issuance of Proclamation number 475, declaring a state of calamity in the island of Boracay and temporary closure of the island as a tourist destination for a period of 6 months. Petitioners Zabal and Hakusalim are both residents of Boracay. Zabal claims to build sandcastles while Hakusalim drives for tourists and workers in the island. Petitioners base their locus standi on direct injury and transcendental importance doctrine. Respondents are sued in their capacity as government officials. So this case relatively stemmed on the issuance of the Proclamation number 475 for the closure of the island as a tourist destination. So petitioner argues that Proclamation number 475 is an invalid exercise of legislative power. They posit that its issuance is in truth a lawmaking exercise since the proclamation imposed a restriction on the right to travel and therefore substantially altered the relationship between the state and its people by increasing the former's power over the latter. Simply stated, petitioner posits that Proclamation number 475 partakes of a law issuance of which is not vested in the president but to the legislature. Likewise, the petitioner posits that Proclamation number 475 is unconstitutional for it deprives the right to due process. Respondent, on the other hand, claimed that the issuance of Proclamation number 475 is a valid delegated legislative power. It anchored on Section 16 of the Public Act number 10121, otherwise known as the Philippine Disaster Risk Reduction Management Act of 2010, or the authority given to the President to declare a state of calamity. They likewise contend that Proclamation number 475 was issued pursuant to the President's executive power under Section 1, Article 7 of the Constitution. Respondent dispute petitioner's allegation that Proclamation number 475 infringes upon the rights to travel and to due process. They emphasize that the right to travel is not an absolute right. It may be impaired or restricted in the interest of national security, public safety, or public health. Respondent challenged petitioners' claims that they were deprived of their livelihood without due process. Respondents call attention to the fact that Zabal and Hakusalim, Zabal as sandcastle maker and Hakusalim as driver are freelancers and thus belong to the informal economy sector. This means that their source of livelihood is never guaranteed, and is susceptible to changes in regulations and the overall business climate. So in any case, petitioners' contentions must yield. So the issues of this case are whether or not Proclamation number 475 constitute an impairment of right of travel. Number 2, whether or not Proclamation number 475 is a valid police power measure. And number 3, whether or not Proclamation number 475 impinges petitioners' right to due process since they were deprived of their right to work and earn a living. So the court ruled in issue number 1, no. Proclamation number 475 does not constitute an impairment of right to travel. So the activities proposed to be undertaken to rehabilitate Boracay involve inspection, testing, demolition, relocation, and construction. So this could not have been implemented freely and smoothly with tourists coming in and out of the island, not only because of the possible disruption that they may cause to the works being undertaken, but primarily because their safety and convenience might be compromised. So any bearing Proclamation number 475 may have on the right to travel is merely corollary corollary to the closure of Boracay and the ban of tourists and non-residents therefrom were necessary incidents of the island's rehabilitation. So, in this case, the closure of Boracay does not impinges the right to travel because the closure is only an incident to the rehabilitation of the Boracay. There is certainly no showing that for Proclamation number 475 deliberately meant to impair the right to travel. So the question proclamation is clearly focused on its purpose of rehabilitating Boracay, and any intention to directly restrict the right cannot in any manner be deduced from its import. So it's only the incidence or the consequence for the rehabilitation of Boracay that their travel is temporarily impinges. Also, the closure of Boracay was only temporary for a period of 6 months. Hence, if at all, the impact of Proclamation number 475 on the right to travel is not direct but merely consequential. As to issue number 2, yes, Proclamation number 475 is a valid police power measure. So, police power amongst the three fundamental inherent powers of the state is the most pervasive and comprehensive. It has been defined as the state authority to enact legislation that may interfere with personal liberty or property in order to promote general welfare. As defined, it consists of imposition or restraint upon liberty or property, and in order to promote common good. So it is not capable of exact definition, but has been purposely veiled in general terms to underscore its comprehensive embrace. Police power is not a force without limits. It has to be exercised within the bounds lawful is through lawful means, and that the means employed are reasonably necessary for the accomplishment of the purpose, while not being unduly impressive upon individuals. So now thus, the question, was the temporary closure of Boracay as a tourist destination for 6 months reasonably necessary under the circumstances? Yes, the court ruled yes. The closure of Boracay, despite temporary, gave the island its much needed breather, and likewise afford the government the necessary leeway in its rehabilitation. Also, time is of the essence. Every precious moment lost to the detriment of Boracay's environment and of the health and well-being of the people thereat. So hence, any unnecessary distraction or disruption is most unwelcome. It must be noted that the rehabilitation consists of a construction, inspection, testing, demolition, and relocation of the area. So it needs a further time to rebuild or rehabilitate it. And the court ruled that the 6 months period, if not truly a possible time, it is the most necessary, and it was the most necessary or the most practical and realistic means of ensuring that rehabilitation works in the island are started and carried out in the most efficacious and expeditious way. So absent clear showing of great abuse of discretion, unreasonableness, arbitrariness, or oppressiveness, the Supreme Court will not disturb the executive determination that the closure of Boracay was necessitated by the foregoing circumstances. As earlier noted, petitioners totally failed to counter the factual basis and justification for the challenged executive action. Undoubtedly, Proclamation number 475 is a valid police power measure. To repeat, police power constitutes an implied limitation on the Bill of Rights, and that even liberty itself, the greatest of all rights, is subject to the far more overriding demands and requirements of the greater number. Let us now come to issue number 3. The court ruled no. Proclamation number 475 does not impinges petitioners' right to due process since they were deprived their right to work and earn a living. So the court further explained that a profession, trade, or calling is a property right within the meaning of our constitutional guarantees. One cannot be deprived of the right to work and the right to make a living because these rights are property rights. The arbitrary and unwarranted deprivation of which normally constitutes an actionable wrong. So under this premise, petitioners claims that they were deprived of due process when their right to work and earn a living was taken away from them when Boracay was ordered to close as a tourist destination. So it must be stressed that when the conditions so demands as determined by the legislature, property rights must bow to the primacy of police power because property rights, though sheltered by due process, must yield to general welfare. Vested rights are fixed and alterable and irrevocable. A right is not vested unless it is more than a mere expectancy based on the anticipated continuance of present laws. It must be an established interest in the property and not open to doubt. To be vested, to be vested rights in its legal sense, a right must be complete and consummated, and one of which the person to whom it belongs cannot be divested without his consent. In this case, Zabal and Hakusalem has no vested rights to their sources of income in Boracay. They are part of the informal sector of the economy where earnings are not guaranteed. Their right to whatever they may earn from tourist arrivals in Boracay is merely an inchoate or one that has not fully developed and therefore cannot be claimed as one's own. It must be remembered that property rights in its legal sense must be complete and consummated and not open to doubt. In this case, Zabal and Hakusalem, their right to earn a living is merely an inchoate or one that has not fully developed and therefore cannot be claimed as one's own. An inchoate right is a mere expectation, which may or may not come into which may or may not come into fruition. Sorry. To repeat in this case, Zabal and Hakusalem has no vested right because the right is merely an inchoate right, which is a mere expectation which may or may not come into fruition. Certainly, they do not possess any vested right in their sources of income, and under this context, their claim of lack of jurisprudence collapses, and it cannot be raised by them. Besides, Proclamation number 475 does not strip Zabal and Hakusalem to work elsewhere. So they are not, they will not be able to do so in Boracay. So in this case, Proclamation number 475 does not prohibit Zabal and Hakusalem to work in the other places because they only focuses that their income because of the closure of Boracay will be impaired. So in this case, since their vested right is merely an inchoate right, they cannot claim that they were deprived of due process of. So that ends the presentation of Group 7. Thank you and good evening.